Hello, everyone. During these challenging times of political intolerance or even intellectual intolerance, if you will, it is very important for employees and employers in California to know that the workers have this anti-retaliation protection in the law. Uh, California Labor Code Section 1101 prohibits retaliating against employees for engaging in a political activity. So if an employer reprimands, disciplines, suspends, demotes, or terminates an employee for engaging in that type of activity, for engaging in a political activity, that would be illegal. A common question in these types of disputes, in these types of cases, is whether the activity that that employee engaged in is in fact a political activity. And there are a number of cases out there that would guide you in the right direction and would answer this question by way of examples. Some of the common activities that are protected, for which it would be illegal to retaliate, are advocating a certain political view or advocating for a particular candidate that is running, who is running for the office, or advocating against a certain political idea or against a candidate, whether you do it in person or whether you do it online. So we know that it's been happening a lot lately, not just in California, but anywhere where an employee would be shamed and would be terminated for supporting one party or opposing another party, or where an employee would be fired for having a conversation in which he complimented a political side, which is not exactly aligned with what the rest of the company or the rest of the management agrees with. So these types of actions generally are illegal. One typical example of an activity that might look to be political, but it's not, is when an employee, instead of constructively advocating or opposing a certain view, instead of doing something in a respectful way in terms of communicating a certain political idea, they resort to insults, they resort to inappropriate language or unfounded criminal accusations. So if somebody is simply berating a candidate, or if somebody is saying or writing complete nonsense that doesn't have a specific political goal or specific political idea, the employer can say, look, this has nothing to do with politics. We're not punishing this employee for his political views. We're punishing him for the language he's using. He looks angry. He looks like he might be presenting a danger of violence to the rest of the company. So what does this mean? This means that if you decided to engage in a political activity, make sure that it's constructive, that it's polite, that it's respectful. Avoid writing things that would suggest that you create a danger or you call for some kind of incitement or for some kind of violence, and this type of activity will be protected. Of course, this doesn't mean that the employer can still not choose to terminate you, because an employer could say, look, I don't care if it's legal or illegal. This person thinks this way and that way. I don't want this employee in my company. I'm going to terminate them. I might even tell them why I'm terminating them. And if it happens to be illegal, and if they decide to sue me, I will deal with it at that point. So the first question that you have to ask yourself, just like in any other type of retaliation case, is even if you're going to have a case against your employer, is it worth it for you to take the risk of engaging in that activity and risking your employment with that company? In some cases, the answer would be yes. In some cases, the answer would be no. Only you can answer that question, because it will depend on your personal circumstances, how much you care about that job, how likely you think they are to retaliate against you, and whether or not you can afford taking that risk financially, socially, and otherwise. Thank you.